is Top Story with Evans Mensah.
And Top Story is always brought to you by Vodafone and Prime Insurance. Countdown to D-Day. With just 8 days more to go before the dreaded e-levy kicks in, it appears the battle lines are tonight deepening. The NDC minority in Parliament is in court seeking an injunction to stop the Ghana Revenue Authority from going ahead with implementation. The GRA last night was, however, emphatic that they will go ahead to tax you the 1.5% on 1st of May, and nothing is stopping that now. Listen to the Commissioner General of the GRA, Reverend Dr. Mishadaya Wuswamwa. Majority Leader Evans Mensah has backed the GRA's resolve to go ahead despite the pendency of the injunction application. He declared the NDC minority's case before the Supreme Court an exercise in futility.
I think that we are behold.
Joy 99.7. Joy 99.7.
And that's Seamus Abungside addressing the news conference today. He says the NDC MPs are too late with their legal attempts to stop the implementation of the tax on May 1.
I think they had the finance minister indicate to us that commencement of the collection, right?
We're also hearing from one of the NDC MPs who, together with the minority leader, had taken this matter to court and had filed this process to place an injunction on implementation in 8 days. Samuel Kudito Ablakwa, who is warning on the back of everything you've heard today from the GRA and the majority leader that they will be in contempt. It says if they persist with what they plan to do, it will be lawless, and that will force the minority side to respond in equal measure.
The majority leader does not speak on behalf of the judiciary, so I treat his comments with contempt. It has no effect at all on our case. He's not the Chief Justice, and he's not the panel going to hear our case on the 4th of May. So that press conference, it's really an exercise in futility. It's just blowing hot air. I've also heard the GRA commissioner, and he will be well advised. Indeed, we are taking note of all of these statements, and we will return to the Supreme Court shortly and draw the Apex Court's attention to these contemptuous statements. This is a war that we are determined to wage in the interest of the Ghanaian people, and most importantly, to uphold the 1992 Constitution of Ghana. 136 MPs cannot purport to have passed the e-levy. They cannot. We must serve a very clear caution that those who are on this path, the path of lawlessness, the path of anarchy, they shouldn't think they have monopoly. We are taking the constitutional path, the legal path. I want to caution the GRA commissioner and others who want to take a lawless path that we will remain committed to the lawful constitutional processes. However, if they compel us, we will be forced to meet them in their terms. We will meet them on their terms, I should say, and we are going to make sure.
What does that mean?
Because if you want to be contemptuous of the courts, if you want to be lawless, the Constitution imposes on us a duty, a responsibility to stop you.
Are you going to cite them for contempt?
And any means that we must use to stop them, we will. But as I've told you, we will draw the attention of the courts that these persons, these agents, these assigns, these privies of government are poised to, as it were, be contemptuous of the courts, to violate our laws, and that the court should take action to hold them in contempt.
Let's go to Parliament now, because this press conference was called today by the minority leader to address a host of issues. And my colleague, Parker Wilson, parliamentary correspondent, joins us on the telephone line right now. Parker, so as far as this matter is concerned, the minority leader is clear that they are too late. The implementation is already happening. And that also to be an exercise in futility. I wonder, because the Parliament has been on recess for quite a while now, was this planned at all?
So we have taken information that recently Evans Mensah had an interview with Muntaka Mubarak, and on the back of that interview, in fact, it was on the day Muntaka Mubarak clashed with the Speaker of Parliament, and Muntaka made the point about some of the things that they intend to do to, one, challenge the approval of the e-levy, and also that decision that the Speaker took in referring the 3 NPP MPs to the Privileged Committee. So it's on the back of this latest information from the minority that we are hearing the majority response, because throughout the whole process we haven't had any majority response on that. So this afternoon the majority leader himself decided to address the issue one after the other. Now, you have touched briefly on the e-levy, which he says it is quite late for the minority to do anything about it because the e-levy has gained the present approval and the law is in full force. Now, the issue about the motion of rescission challenging the Speaker's decision. And you recall that Muntaka had made the point that the Speaker has no business or had no business referring the 3 NPP and to the Privilege Committee. That should have been done by members of Parliament. Now, Seamus Monsu strongly disagrees with him. According to him, the MPs or the leaders of the House have, in some instances, taken petitions form on behalf of the Speaker. Of course, demonstrators come to Parliament to demonstrate and hand over petitions to the Speaker of Parliament. And the Speaker has subsequently directed a committee to look into the petition that has been submitted to him. So, what Muntaka did, or what he is saying, is not grounded in law, and as a matter of fact, he is asking the Speaker to reject that motion, challenging his decision.
I filed a motion of decision on that statement that the Speaker read out. Again, I don't see where his strength is. A motion of rescission. What are you rescinding? A motion of rescission, as contained in our orders, provide that you can rescind a decision of the House, right? A firm decision has been arrived at on the subject matter, but maybe upon reflection, it is seen that what Parliament did was wrong. So you come with a motion of rescission to rescind that decision of the House. What the Speaker did that day, if you heard him, and I believe most of you were there, what did the Speaker tell us? We got to the point where we have communication by the Speaker. So the Speaker, before reading that testament, said that he was coming by communication by the Speaker to give some information. So it is, what he did is communication from, or if you like, by the Speaker. How do you come by motion of rescission? A person gives you information, I'm receiving the information that you are giving. It has no place in our procedure. And it's a dangerous thing that he's doing. Why? If a motion of rescission can be granted on a communication, not even a ruling from the Speaker, because that was not ruling. If the motion for rescission can be granted space relating to mere communication from the Speaker, then we will have a situation where the President communicates to Parliament, and the next day somebody rises up to say that let's have a motion of rescission to the information that the President has provided us. I don't see where his strength is coming from. I thought that really, on the face of it, is farcical and it's strange to our rules of procedure.
So that's the majority leader there on the issues that had been raised by the Muntaka Mubarak, who is a majority chief whip. Parker, very quickly. So this is in response to the motion to stop the referral of the MPs, the MPP MPs, to the Privileges Committee. We know that is something that it's possibly not going to be heard or admitted until Parliament resumes. Is there an indication that the Speaker has even admitted this?
No, we are yet to confirm whether the Speaker has admitted the motion, but as the majority leader is saying, it's farcical and that the Speaker should clearly reject it. In fact, I have been checking with the members of the Privileges Committee. They are still proceeding to go ahead with the hearing of the 3 NPP MPs. What I'm learning is that they don't want to recall the members as they are within the break. So just a week or 2 weeks before the resumption of parliamentary duties, the members will congregate and then the hearing will be done. And then after that, they will present the report to the plenary for a decision to be taken upon it.
Thank you, Parker. Let me speak now to the deputy majority whip, Habib Idris, who joins us on the telephone line right now. Mr. Idris, thank you for your time here on Top Story.
Thank you, Evans.
I mean, the majority leader is aware that there's a case before the Supreme Court, and that seeks to place an injunction on the implementation of the e-levy in 8 days' time on May 1. And yet he describes this as an exercise in futility. That is clearly prejudging the case before the Supreme Court. And is, as we've heard Kujita Blakwa say, he's clearly in contempt of court there.
Far from that, Evans, what the majority leader ought to do was to give clarification on the matter before the Supreme Court, but not to go into the substance of the issue. Mind you, it was a decision of Parliament that the electronic transaction levy was duly passed. But now, if you are sending it to court to say that you are putting an injunction on its implementation, that is the clarity the majority leader was actually giving. Because if a bill is passed in Parliament and it is assented by the President, it becomes a law. So you are now going to put an injunction on the law. The day the President signed assented to the bill, the passing of the bill, it became a law. And then straightforward, it is an automaticity of the procedure to kickstart. Just that because it's a financial transaction, if other things are not put in place for its deduction, it does not mean that it is something still that needs to be done for a new law to be done before it is passed.
Yeah, I mean,
so the President signed to it, it became a law. That's what the majority leader was trying to clarify.
The President signed, in effect, a bill that was before him into law. But that law only becomes effective when the GRA begins to actually collect the funds, the taxes, and take the monies. The minority's position is that is set for 8 days' time on May 1. Stop that, because if the Supreme Court decides on the substantive matter, it would do irreparable damage to all of us if, say, they win the case, for example. That is fundamentally their point. Isn't that a sound point to make?
No.
Isn't that even in the government's own interest to wait until the Supreme Court determines this matter?
No, assuming government was, after the President has assented to the bill to make it a law, 5 days, 6 days after they are already ready to start the charges, they will. But if the minister have said that we are starting it on the 1st of May, and mind you, they already have another case at the Supreme Court. They have filed a case, I don't know, with regards to the passing of the e-levy itself. And now they are now trying to stop the implementation of it. So I still don't even get exactly what they want to do. That is why the majority leader was making it clear to them, to let them understand the procedure in passing of a bill for it to become a law. So now it is a law. For the fact that the GRA haven't started deducting money or implementing it doesn't mean that it is not a law. It is a law in our books. All procedure have been exhausted. There was a motion in Parliament, moved, it was referred to the Committee on Finance, it came back to the preliminary, we debated, second reading, third reading, consideration stage, it was passed, the President has sent his signature. That is all the procedure for something to become a law.
I mean, let's speak to Roxin Dafiamekbo, your colleague on the Legal and Constitutional Affairs Committee on the minority side. Roxing, I mean, the majority leader, James Abungsa, had a point when he said today at the press conference that this exercise to injunct the implementation of the e-levy is an exercise in futility. You listen to the head of the GRA. They are ready to roll this out in 8 days' time. They are actually not stopping. He says May 1 is the date, and they're going to go ahead. It's been signed into law by the President, and so it is law already. And so what are we really seeking to stop?
Now, Evans, thank you very much. It appears that the majority have refused to appreciate the position of the minority in this matter. I have heard the majority leader say, for instance, that we have not exhausted the procedure in Parliament. And why are we in court?
Have you though?
What procedure is available for the minority in Parliament to pursue? You have passed a bill into an act and quickly submitted the act to the President for him to append his assent to it. So it's become a law properly so called. But as an executive arm of government, you have decided to suspend the implementation of that law to the 1st of May. Parliament hasn't given you that power. You are exercising an executive power to suspend the immediate implementation. The minority are alleging forcefully that the constitutional provision regarding the procedure adopted in passing a bill into law in Parliament have been breached. When that allegation is made, Parliament is no longer the forum to remedy that. The forum convenient to remedy that is the Supreme Court. So that has been done. So when they are running around saying the bill is being passed into an act of Parliament and therefore the Supreme Court cannot injunct it, they don't understand what is before the court. What is before the court is that the procedure leading to the passage of the bill into law is unconstitutional. So the Supreme Court has the power to make the pronouncement that the law that has been enacted on that basis should be struck down, the entire law, and that we should go back to Parliament and do the proper thing.
But that's the first part of your case in court. I don't think James Abos had a problem with that. His problem is with the second application to injunct it while the substantive matter is being heard. He says that second part.
He raised that matter by saying we have not exhausted the internal remedy in Parliament. And I want to tell him that once they passed the bill into an act and submitted it for presidential assent, Parliament has become Fantus official. So we can no longer remedy the defect in Parliament. The remedy must occur at the Supreme Court. So you should appreciate that. Then based on the substantive case, we have premised an application or notice for an interlocutory injunction. The conditions for the grant of interlocutory injunction have been properly canvassed in the application. And yet he goes out to say that it is frivolous. It is his argument to make. But suffice it to say that if on the 4th of May the Supreme Court grants the application, what will he be saying? So as the leader of the House, I will urge him to cease fire, to cease all public comments on the matter, and leave the Supreme Court to make the determination of the application or notice on the 4th of May. The Supreme Court has the power to strike down any law that has been passed by Parliament on grounds of unconstitutionality. So many provisions of our laws have been struck down by the Supreme Court on grounds of nullity. So let nobody tell you that the Supreme Court hasn't got the power to strike down the e-levy on grounds of unconstitutionality if they so find, which we are urging upon them to do, because the procedure adopted breached Article 102 and 104 of our Constitution.
Today,
in terms of quorum and all those gamut of factors.
Today, Okudzeto Ablakwa, who is one of the applicants in that case, says the Chairman Sabunsu's comments and what he's heard the GRA also asserted last night on the same network that they're going ahead, it's all contentious of the court. You are a lawyer. You agree with him?
I do so.
Why?
Because you see, those comments are contumacious of the powers of the court. Contumacious in the sense that the court has the power to suspend the implementation of the law in the same way that the executive has suspended the implementation. So if you say that you will have the power to suspend the implementation for say 30 days, but the court cannot do so, and when the court makes the pronouncement on the 4th of May, what would have become of your comment to the effect that they will go ahead and implement it? So the declaration that they will go ahead, notwithstanding the pendency of the interlocutory application asking for an injunction, is contumacious of the powers of the court, is contemptuous, and the court ought to suo motu invite these two entities, the heads of these two entities, for the appropriate thing to be done.
I mean, let me bring in Mr. Dries. Mr. Dries, so as it stands now, Parliament is on recess. You're raising issues with the processes in court to try and injunct the implementation, but you also swayed today in the arena of a different subject, which is the referral of some of your members to the Privileges Committee questioning the minority's decision to file. Well, the minority chief with decision to file this motion to arrest, to try and stop the referral. You say, from the minority leader's position, that attempt in itself is wrong because it was just a referral that was made. I mean, that is for the speaker to decide, is it not?
Yes, even before I even jump into that, my colleague was making the statement that the passage of the e-levy itself is questionable. I don't know. That's why I'm saying that there are two applications before the Supreme Court. It's rather unfortunate and completely unnecessary. Nothing was breached in the passage of the e-levy, and for it to be passed into a law at the moment. So if you are in the court, when you go to the court, you'll be able to prove your case. The implementation of the e-levy will be on the 1st of May, and understand that the hearing of their injunction is on the 4th of May. So the court will definitely decide, but what I do know is that it's completely unnecessary, and it's just to distract the procedure and pollute the minds of Ghanaians that the bill, having, like I said, there is procedure for every bill to be passed. For the fact that you have participated in a debate of a bill, it says in the second reading, and our standing orders have made it clear, it is not voting. If you go and look at 113 of the standing orders, it says that when a question has been put by Mr. Speaker at the conclusion of the debate, the vote shall be taken by yes or no. That is what they have failed to understand.
Yeah, but you agree with him. But you agree with him when he reacts to Chairman Sabunsu's point that they should exhaust the processes in Parliament. That the processes in Parliament have been exhausted. You've already passed. The president has assented. It's done and done.
So it's completed, and that is why I'm saying that the processes in Parliament. And if you even listen to them carefully, you definitely will not be able to understand exactly what their case is. It's the case that the passage of the bill, we are 136, we are 137. I don't know which one they are trying to do. And then the other thing is that who can ascertain that number? The difference between this one, Evans, the difference between this e-levy passage and that of the previous budget rejection they did, at the end of the day, there was a count. And the speaker announced in the budget that those who say yes was 0 and the no was 137. In this case, the question was put on yes or no. Nobody was there to challenge it for it to be able to count. And the funny part they have actually failed to realize is that day, after the passage of the e-levy, the minority leader had made a press conference, and he stated that the member of parliament for Asim North had not finished filing his papers and was still in the office and could not come into the chamber. Invariably, you are admitting that after the time we were taking the decision of the e-levy, the member of parliament for Honorable Koisin was not a member of parliament. That is why he could not come into the chamber, because he was actually avoiding Article 105, knowing very well that he can't participate in parliamentary proceedings because he was not a member of parliament. So if at that material moment he was not a member of parliament, how many members of parliament do we have in Ghana?
Okay. Mr. Bibidris, thank you very much for your time. Roxanne Defemepo, I'm grateful also. The Supreme Court will have to decide this, but the ticking clock is moving pretty quickly towards the 1st of May, with just 8 days more to go for that tax to kick in. The Supreme Court will have a say on this later. We'll see where the pendulum swings. And that's it for Top Story, always brought to you by Vodafone.